I'm going to talk about the right to bear arms, and it seems like it would be a simple topic. The Second Amendment provides that the right of the people to keep and bear arms shall not be infringed, and the question is being hotly litigated in the minority of states that have so-called discretionary license issuance for carrying handguns. Whether bear arms means that you have some kind of constitutional right to carry a firearm outside your home. And the first thing is just the words of the Second Amendment would seem to be conclusive about that. A right to keep arms and a right to bear arms, those are distinguished. Keeping arms would obviously include keeping them at home. So bear has nothing to do if it means that you can carry arms in your home. It's got to be something more than that. And by the way, when the Bill of Rights restricts some element of the subject to the home, it says so very clearly. In the Third Amendment, for example, soldiers will not be quartered without the consent of a person in that person's home unless in times of war. So when there's a restriction of an activity to the home, the Bill of Rights plainly says so. The word houses appears in the Fourth Amendment, obviously, in terms of search and seizure issues. So really there's nothing for the word bear to do unless it means that you can carry a firearm. And when reference is made to the right of the people, one would think that that would include society at large, people, individuals at large, and not those that would be chosen by government to exercise a given right. You cannot imagine referring to the right of the people to assemble in the First Amendment, and the government gets to decide who has that right, and you have to get a license, and you only get it for a good cause or for some reason that's different than other people. So that's the text. And then we move on to District of Columbia versus Heller. It's true that case, the complaint in that case alleged that there's a right to keep arms in the home and that therefore the DC handgun ban was unconstitutional. And of course the court so held, but there's a lot in that decision about the right to bear arms, the right to carry arms. And in fact, Justice Scalia's opinion goes into great detail in the course of refuting the idea that bearing arms only refers to bearing arms in the militia, about the fact that carrying arms is what bearing arms means. There's a good quote in that case from Justice Ginsburg from a decision under 18 U.S.C. 924C about what it means to carry or to bear arms, and she refers to the familiar language of the Second Amendment and states that means carrying, for example, a gun in the pocket or otherwise on the person. And as you just heard, the Heller decision also refers to restrictions on the right, the Second Amendment right. Generally, one of those was that you cannot carry in sensitive places like schools and government buildings. That would seem to imply that, non-sensitive places are places where you can carry. So in addition to that, the decisions that the court relies on in Heller talk about the right to actually carry arms, handguns, for example, and the court refers to some of the 19th century cases, Nunn versus State from Georgia and then Andrews versus State in Tennessee. In those two states, there were times when the legislature declared a prohibition on carrying handguns either openly or concealed, and those laws were invalidated. And Heller, toward the end of the decision, states that, well, the D.C. law is somewhat like these laws in the 19th century. It's so extreme in terms of prohibiting the right to bear arms altogether, and in the same token, the District of Columbia was prohibiting the right to merely possess handguns altogether. One more part of Heller makes clear that under the basis of the court's decision, although the issue wasn't squarely before the court, that there's a right to carry outside the home, and the court refers to the fact that, well, the Second Amendment has a militia clause, but for the people who lived at the time of the founding, even more important to them was the right to carry arms for self-defense and for hunting. So these are all activities. You don't go hunting in your home. You don't. You may or may not have to defend yourself in the home, but certainly militia activities do not take place in the home. So there's a lot in Heller to go on here in terms of predicting what might happen in the future in the court. And we move on to McDonald versus the city of Chicago, which applied the Second Amendment to the states through the 14th Amendment. The very first carry law that the court refers to in terms of what the 14th Amendment was intended to invalidate was the Mississippi Black Code from 1865, which provided that no African American, no freed person, no freed slave could carry a firearm without some kind of permit from the authorities. And in fact, those types of statutes pervaded both the slave codes and then later the black codes from the early Reconstruction period, requiring a permit that's solely at the discretion of the issuing authority in terms of whether the person could have a right to bear arms. And so there were a lot of African Americans who were arrested and prosecuted and their guns seized and confiscated under these laws. And you'll see speeches in Congress about the purpose of the Second Amendment in terms of wanting to get rid of these laws and validate them. You also have the passage of the Freedmen's Bureau Act in 1866, which under which 2/3 of the same Congress that passed the 14th Amendment and sent it to the states for ratification, 2/3 of the same Congress voted for the Freedmen's Bureau Act, which explicitly declared that the rights to personal security and personal liberty included the right to bear arms. And they were referring to the right of African Americans to have the rights of full citizenship, which included the right to carry arms outside the home. Now, there's a third Supreme Court case that it was like Mark Twain said, the reports of my death have been greatly exaggerated. If you remember, after Heller and McDonald, the Supreme Court wasn't granting cert in any Second Amendment cases, and it was like, maybe they're never going to take another one. And then all of a sudden, they took a case based solely on the petition, the cert petition and the opposition to it from the state of Massachusetts involving the stun gun ban in that case. There was a woman who had been threatened and beat up by her ex-boyfriend, and she had a stun gun, and was busted in a parking lot with the stun gun, which was prohibited under Massachusetts law. And the Massachusetts Supreme Judicial Court upheld that law, and it went to the Supremes, and they said, hold on, like your reasoning is totally out of whack with what we held in Heller. The weapon doesn't have to be a type that existed at the time of the founding, that because Heller had made clear, just like modern communications and exercise of free speech and free press, there was no internet at the time of the founding, but under the speech and press clauses, the internet is still protected. And by the same token, the types of weapons, if they're commonly possessed by law-abiding people for lawful purposes or typically possessed for lawful purposes, they're protected by the Second Amendment. And so the Supreme Court, simply on the basis of the petition and opposition, reversed and remanded the Massachusetts court and said that go back and look at this again under our precedents. You've not been consistent with what we've ruled. And the interesting part about that case, which there's more detail about it in Justice Alito's concurring opinion, is that it took place outside the home. So had the court thought that there was no right to carry any kind of arm outside the home as guaranteed by the Second Amendment, the court could have dealt with the case that way. There was no reason to go into the analysis of the type of weapon. So yes, the court didn't make that explicit proposition, but that was assumed in the case, and that was a 9-0 per curiam opinion, assuming that there's a right to carry outside the as the judge mentioned, the Gould case out of the First Circuit is one that my colleague John and I participated in different roles. He got to argue. I didn't get to do that. But what's funny about these cases, or interesting, is how the turn into like ancient history it becomes a big part of the case. Specifically, you see a lot of briefs about the Statute of Northampton from the 1300s in England, and that was 50 years before Chaucer wrote the Canterbury Tales. How many of you remember reading that in high school, the Canterbury Tales? We were just high school kids. We thought it was really funny. I remember the phrase, somebody called somebody else a naughty knave and a saucy fellow, and we thought that was just hilarious. But here's a statute that the argument seems to be that it overrides the Second Amendment because it was something passed by a monarch in medieval England, and that's become a big part of the briefing. And it's really fun to do that kind of briefing, but like the D.C. Circuit said in the Wren case that overturned D.C.'s discretionary license issuance regime, that we're not turning the clock back to the time of Chaucer, and that's not what the Second Amendment talks about. It talks about the right to bear arms. Look at the text and the structure, and look at the different decisions. Look at the Heller and McDonald cases, and so we're not going to be bound by those old laws. What the Statute of Northampton did was to prohibit going armed, riding or going armed, and it also had language about doing so to the terror of the king's subjects. And the way the English courts ended up construing that was it was an offense to go armed only if you did so in a manner that terrified other people. So if you were carrying concealed, obviously you wouldn't be doing that. Or if you were simply peaceably going about your business, you wouldn't be doing that. And but anyway, in that debate, there's a case, Sir John Knight from 1686, and the court agreed with that construction of the Statute of Northampton, that it only precluded going armed to the terror of other people. Then you get to William Hawkins and Blackstone and all of these people, and so you'll have a lot of arguments. So it's really fun arguing these really old authorities, but they don't count as much when you look at the text of the amendment and the fact that we have Heller and McDonald giving a lot of guidance in terms of what the amendment protects. And we also have to look at the unique situation here in the U.S. What parts of the common law did the colonists carry over? The first declaration of rights to mention a right to bear arms was that of Pennsylvania, and it referred in 1776 to the right of the people to bear arms for defense of themselves and the state, clearly an individual right. You have different variations of that being adopted before the Second Amendment by other states. And then finally, you have the Second Amendment itself. And we used to debate whether the Second Amendment referred to a collective right of basically nobody to keep and bear arms, the National Guard or whoever it would be. And that argument became abandoned by the time of Heller, and you'll see even in Justice Stevens' dissent, he wants to talk about a individual right to bear arms in the militia, and that's the exclusive protection that the amendment provides. In any case, there's no question under these state guarantees that there's a right to bear arms outside the home, and in fact, most states do provide for what are called shall issue license regimes, under which if you meet certain qualifications, like you pass your background check, have certain training, and otherwise, then you can get a permit to carry, and that you can carry for self-defense other than in certain places where carrying is banned. So that's the law in almost all states, but there's, I don't know, maybe 7 or 8 states that have the discretionary issuance. Anyway, what's the Supreme Court going to do? And that's fun to always speculate about, and we never really know what might happen with that. But, you know, in the Wren versus D.C. case, the D.C.'s law was overturned, and the D.C. Attorney General reviewed whether to petition the Supreme Court. And and this was in the newspapers, the attorneys general from other states where may issue license laws existed, and in circuits that have upheld these laws, first, second, third, and fourth, bore down on the D.C. Attorney General, like, don't go there. D.C., you made this mistake once before when you insisted on taking the handgun ban case to the Supreme Court. And that ruined everything to start with. I mean, that did away with the Second Amendment as only a collective militia right theory. And the Second Amendment does mean something, so don't do it again. And the D.C. Attorney General, therefore, did not petition the Supreme Court. And so we have 3 circuits, basically, in agreement with that. And that would be the D.C. Circuit, the Seventh Circuit, and well, this is kind of weird, the Ninth Circuit. The Ninth Circuit has gone in different directions. First, there's a case called Peruta versus San Diego, where discretionary license issuance was upheld for concealed weapons. California, during that litigation, also banned open carry of handguns, but the court refused to deal with that issue. It started out the policy of discretionary issuance was invalidated by a panel decision 2-1, and then in Bonk, though, the Ninth Circuit reversed and said that discretionary issuance on concealed weapons is okay, but we're going to close our eyes to whether you can carry firearms openly under the Second Amendment. And so you have some strong dissents to that. But then the same issue came up again. The state of Hawaii doesn't issue any kind of licenses. The only license you can get is an open carry license if you're a security guard. And a 2-judge panel with 1 dissent held in Young versus State of Hawaii that that can't be the meaning of the Second Amendment. It's not limited to security guards. And so that panel said that that policy was invalid. And of all things, that was a preliminary injunction case. It went up to the Ninth Circuit, and the Ninth Circuit affirmed at that level under the preliminary injunction standard that the case was sent back for further proceedings. So as of that decision, the Ninth Circuit is on the record saying that you can carry openly, and that's guaranteed by the Second Amendment, but not concealed under the en banc Peruta decision. So Judge Gorsuch on the 10th Circuit made some comments about Second Amendment issues, but more in terms of felon in possession issues. And you might have noticed the court's grant of cert in a case involving whether it's an element of the offense that the government has to prove a felon knew of that status as a prohibited person. There was a 10th Circuit case that Judge Gorsuch dissented in where the state court judge had said to the defendant that you're not a convicted felon because the case was going to be somehow nullified at the end of the probation period, something like that. And so the guy possesses a firearm and then he gets prosecuted for it despite that advice. And so anyway, that's not a carry case, obviously, but that's something that a case where an opinion was rendered that did involve Second Amendment issues. And then we've got Judge Kavanaugh, of course, who dissented in the Heller 2 case, about which you'll hear more later. He would have held not only that the D.C. ban on semi-automatic rifles was contrary to the Second Amendment, but also that the parts of the D.C. gun registration system was also not justified under the Second Amendment, and he used the methodology of text, history, and tradition as opposed to levels of scrutiny like strict scrutiny or intermediate scrutiny. So there you have an understanding of the Second Amendment that I think would be potentially favorable to hearing the issue of the right to carry if the Supreme Court does grant cert. So we've got some new kids on the block, if I can use that term, in the court, and so we'll see what the court does next. But that's what makes this subject so much fun, and thank you very much.
Thank you.